No volume. There we go. Okay.
Hello, Jason, can you hear me?
Okay, yep. Yes.
Oh, thank you.
All right, we got it all going.
Okay, I just wanted to talk with you because I don't feel that we're kind of on the same page here, and I'm concerned as this matter goes on that things are just going to get worse. And so I wanted a chance for some back and forth and try and figure out, what we're going to do with this, what choices you want to make, but also with some realistic expectations of what can happen and what's at risk for you.
Okay.
Okay. One of my concerns is that as you identify most of these issues, effective either in communicating about it or from a defense standpoint. You are correct when you indicate that they have to prove it. And the nature of these charges are always a kind of a vague, weird thing because we've got a right to most types of actions that affect speech and that kind of thing. It's when those butt up against someone else's rights or safety that those can be infringed. And they've got to show a couple of things. You are right that just a second, let me hang this up. They don't have to prove your statements to be false. That's not really the issue. That some of it can be the sort of harassing nature and unreasonably to expose somebody to ridicule. Truth is a defense in it that we can show that they're true. But when your statements are conclusions, we can't show that conclusions are true by restating conclusions. And that's the trouble is almost everything you say is descriptive and conclusory words. If we remove those words, there aren't any left. And so, I need to know what it is you allege that supports those things without the descriptive words. And does that make sense?
No. Because without the words, how do I have the charges? So I gotta, I guess, back up those.
Without descriptive words. For one thing, to call someone a child predator and just essentially say, well, the case supports it.
Okay.
That's what I mean. If I say that someone is a child predator and you ask me why, we'll say, well, he drives around in a van and he's kidnapped 4 children and he sexually abused them.
I never said anything about sexual. You mentioned sexual. And anybody else that wants to put sexual on the term predator, that's on them. That's not me. I've never said sexual. Not once.
But I'm making Jason, first of all, that was an example.
I understand that.
The difference between making a statement
poor choice of an example.
Back it up. But the other, no, it actually isn't, because when you say child predator, that's the first thing that comes to mind.
That's not on my.
That's not my. Like that.
That's not my problem. I chose professional words that in a dictionary, that's what they are. And as a predator, that's what he is. He has damaged my relationship with my children, has damaged my children's future by agreeing to and upholding a year non-contact order to my children. He prevented any kind of chemical evaluation into my divorce to show that I am a parent, proper functioning parent. So that's a predator. I am somebody's child. I am my mother's child. He has caused me damage for the last 6 years. And he obviously doesn't care about anything that he's doing because this has been brought on because of him, not me.
But Jason, the things that you describe, they're ordinary rulings in a child custody proceeding, and to connect it up and then use the term predator, that it doesn't fit, and it's extreme, and it becomes harassing, and if you're going to stay
So
on
does
that
his
page,
action
you've
on
got
my
this.
children. So does his actions on my children. There is no reason for him to be sitting on that position that he's in. He has charges against him, like I stated, that should
What
prevent
are the
him from.
charges?
His
What are
charges
the
are out
charges?
are from Helena for pandering underclassmen. So the same thing he was doing.
I don't understand what that is. That are you talking about a criminal charge?
Yeah, and it was,
Okay, I don't understand that criminal charge. That's not
and
anything I'm familiar with.
neither does the general public. But if that once that comes to surface and everybody finds out about that, he is not fit to sit.
But that's what I'm saying. I'm asking specifically. You say he's charged. What charges did he have? Who brought them? What court? And what's the actual charge?
Out in Lewis and Clark County. One second, I need to pull up my Facebook.
Okay.
And he's guilty of it doing it in my divorce. So everything, that's why I say everything in 17-0018, anything he touched is a fraud, waste, and abuse charge. He ignored what I have 13 motions I put in for requests. Only one was authorized because it was a request to have her have a psychological evaluation. That's the only one he denied. But other than that, everything I requested to interview my children, everything. So he is a predator.
Well, but Jason, that's not a logical statement or conclusion. What I'm
No,
saying
that's
is that
just
when
a
they
fact.
present this. The difficulty here is you want to hold on to your anger and your personal
I'm not
opinions,
holding on to
despite
anything.
that they've
The
got
only thing I'm
repercussions.
doing is sticking up for my children. You can call it what you want. I haven't seen my children, and my children haven't seen me for 6 years. All I'm doing is sticking up for them.
So what is it you want to happen here? Do you want to discuss a plea agreement or do you want trial?
I want a trial unless the plea agreement gets me my property back, my kids back, him off the bench, him signed up, him never to practice again, him to lose his license. That's the plea agreement I want. Otherwise, I'm going to trial.
You know that that's not real and that doesn't exist. That's
then
not a
then I
plea
guess we
agreement.
go to trial because that's the only thing I want. I want my children. I want her to have a psychological evaluation that is obviously needed because for her to ask and request and get approved a year no contact order after I spent every day with my children at school, get out of here. I want that or I'm going to trial.
Well, there's no one who can even discuss that. So that's not something that exists as part of this case.
Well, it does
And
because
to use all up together.
that's
It
what
does.
predator comes from. Any
No,
predator, he's a predator.
this is a
If they want,
Jason,
if they're
this is a
coming,
criminal case.
I understand that. But if they're coming after me for calling him a predator, tax evasion, and anything that's on that poster, then fine. Then I have to back every word up on that poster, and every word on that poster is provable with facts. I mean, that's it.
But because he didn't rule in your favor on motions in a child custody case, doesn't equate to predator. That you used a charged statement, and you're not discussing it rationally, and that means that trial is going to go poorly.
That's okay.
Because when you say facts, one of the things we can't do at trial is present the jury and go, well, look, I filed this motion and he denied it. We cannot do
No,
that.
but I can say I filed 13 motions and he ignored all 13 of them that have to do with my children. Predator, a person or group that ruthlessly exploits others.
That's not exploitation. That's rulings on motions in a court proceeding. That's not exploitation in any fashion or stretch of the imagination. It's rulings in a court proceeding, Jason. Your conclusions in that regard are so unreasonable, you're not even going to get a statement. If you try and testify like that, you're not going to get to say all of that. The judge is going to shut that down. Those aren't factual statements. That's what I mean by conclusory words. You assert that one thing equals another, but it doesn't. A litigant who files a motion, just because it's denied, that doesn't mean the judge is, quote, a predator. It means the motion got denied. If someone files 100 motions that have no basis in law, 100 of them will be denied. That does not make the judge anything.
But at least that judge denied them. But at least that judge would have denied them.
Did you appeal, and did a higher court say he was wrong? I'm trying to provide you some legal help here, and I can't do it when you won't communicate reasonably, when you will hold on to these ideas so firmly, and it's so personal to you.
Well, yeah, it's because I have children, and he's done this to other people, and it won't stop until it's done. It is what it is. So I'm going to trial. Whatever. Bring my children up there. See if they're damaged because of this. Because I guarantee they'll say yes. Bring counselors. Bring psychologists. I don't care. He's a predator. People agree with me.
Okay. Have you been through a trial before?
Sorry?
Have you been through a trial before?
I have not.
Okay. Then I think that we should discuss how that goes as a practical matter, because I think your vision of it is not how it's going to be. And so I think we should run through that step by step.
Okay.
Okay, just a second. I'm going to shut this other thing down. So I'm getting annoying messages. Okay. First of all, of course, I think you can anticipate how the state's going to do this. Is they're going to call their various law enforcement officers, and they're going to, say that this was found on Facebook, this was hanging on the Toby's Ark building, this was hanging on his fence, and they're going to focus on those various statements. Both with Parker, it'll be primarily the child predator allegation. And with the other person, it'll be that statement that she's the face of now I can't remember what the specific words that you used were, but they'll present that. Then, on the face of it, their assertion is that those are kind of hateful things designed to expose Judge Parker to ridicule, to expose them both to scorn and ridicule, and which they were. I mean, the truth of those statements, there's no way to look at your statements and think that they aren't. And even when you talk about why you do that's quite apparent. So then the question becomes, when you testify, if you choose to, can you show that there's truth to them? And that's what I'm saying, where the difficulty is. You can't just say, oh, it's in the file. That's not an answer. We don't get to hand the divorce file to the jury.
Right.
That's not how it works. You can testify to facts. And saying well, I filed 13 motions and he didn't grant them. That, first of all, that doesn't mean anything with regard to a statement of calling someone a child predator. It simply doesn't. If you think about that,
I'm going to name every motion that he ignored. Like you said, a judge denied. Okay, well at least that judge denied, and I'm going to tell the jury this judge wouldn't even deny or grant me anything. It was totally ignored, and this is for children. So yes, he's a child predator. Case closed. Now, do we want to talk about tax fraud and why I'm sitting here, and now we're paying 5 jurors? Let's talk about tax fraud because this started 6 years ago.
Who committed tax fraud?
It would be the system he sits upon. I spent 80 days in jail. That's tax fraud. That's abusing the taxes, the taxpayers.
No, it isn't. That's not what Jason. That's not what tax fraud is.
No, that's tax fraud, waste, and abuse. Fraud, waste, and abuse. Excuse me. I'll get all 3 words in there.
Well, it's problematic that you sum things up like that and just use that mantra to represent everything. That's not.
It works in the military.
You're not in the military. This
no, but this is the government. It's an abuse of the powers that he's sitting on. That's what it is. He knows it. You know it. Everybody knows it. We all know it. Society knows lawyers and judges act like this. It just takes somebody to call you out on it.
Jason, those are nonsensical statements.
That's fine. That's my trial then. Because I'll prove it.
Okay, but what happens, Jason, when at some point the judge just tells you to stop talking? What are you going to do?
I stop talking, I guess. I stop talking.
Well, because he's gonna.
Okay.
That's what I'm trying. What I'm trying to say.
Then I'm going to say he's stopping me from giving factual information. Well, because that's all I have to give and give to offer. Is just facts. This is all I'm doing.
Okay, a large part of what you think are facts are not facts.
Okay.
They're again descriptive words. Descriptive words are not facts by themselves.
Okay. I have, like I said, DDR 17-0018 and everything included in there that I can open up every file, every motion I put in there, and I can discuss every motion with the jury.
No, you actually can't. You will not get to micro litigate that case in front of a jury. You absolutely will not.
Well, there you go. Then I'm being denied access to facts. That's what that'll be. Then I'm being oppressed from using facts from a case that proves this case.
Okay, but Jason, I don't know how to explain that to you. I'm struggling because we're not able to understand each other in that fashion. You can't relitigate a civil case.
I'm not trying to. I'm just using facts from a civil case. That's it.
Right, but the denial of a motion or even the ignoring of a motion does not equate to, quote, child predator. That's a charged statement.
Okay, but I'll let that be the decision to the jury because it's fact. Not just once, 13 times.
Okay, what I suspect will happen, Jason, is that if I ask you questions about your basis for that statement and you testify to those things, I anticipate that at some point in that, the judge is going to say, not relevant, and you don't get to litigate that. That's
Okay.
what I anticipate, and I want to prepare you for that.
And I'm going to, I guess, just say then you're oppressing me and with allowing the withholding of facts. It is what it is.
Okay, but then what happens if you get convicted?
I appeal it.
Okay, I assume that was your answer. So then on appeal, you know how that appeal process works.
Do tell.
When you file an appeal of a justice court action, the district court will then review the transcript for whatever allegations you make that are the violations, the legal mistakes, if you will, and um, then but if they uphold it, which on what our general topic of what we just said, you're wrong, and they absolutely will uphold the judge doing that to you. And then what do you do? What if he gives you jail because your answers are offensive and they're concerned?
Because, well, that's what they all want anyways.
Do you want to go to jail?
That's what they all want anyways. That's what my ex-wife wants. That's what they want. I spent 80 days in jail. I spent another 3 days. Otherwise, I'd still be sitting in jail if I didn't bond out.
Right.
They want me in jail. They want me silenced because of the fraud, waste, and abuse.
Okay, but my question to you then, Jason, is do you want to try and avoid that as an outcome?
No, I don't understand that question.
Well, you say they want you in jail.
They do.
I'm asking. Okay. And so I'm asking you, do you just want to go to jail and be mad about it?
No, that's why I'm not letting it go to the judge. That's why I'm not letting it go to the judge. It's going to a jury trial.
Okay. Okay. But that doesn't mean that. I mean, let's say the jury convicts you. Okay. The worse that trial goes, as a practical effect, the higher the risk that the judge imposes jail for that.
Mm-hmm.
Because the judge pronounces sentence. The jury decides the facts, but the judge pronounces sentence.
Right.
So what I'm asking you is a practical matter. Do you want to have discussions about your options that potentially avoid that as an outcome? Or do you just want to belligerently march forward, everything be damned, I'm going this direction?
I'm not being belligerent. I'm just telling you, and you keep telling me. We're having a conversation. You don't like my tone. I told you day one I have autism. I have problems with inflection and tone.
Okay. But my concern for you and your future is that if this stuff continues and this matter continues, I don't think it's going to be the end of it. This is going to get worse and worse.
The only way it continues.
I didn't mean to cut you off. I'm listening.
The only way it continues is if it gets the wrong conviction, I guess.
Well, then let me ask this. And of course, I understand we're talking about future and speculative or not, yes. But let's say you go through trial and the judge takes offense at the way you present what you're going to present. Jury convicts you, and he goes, I'm giving you 30 days jail. And you appeal, and it gets upheld. And so you end up getting hauled in, and let's call that 6 months down the road for 30 days. Then is that the end of this, or is there more to come?
Who's to know? I can't give you that answer. That's kind of a.
Well,
that's seeing the. That's seeing the future.
I know.
Let me go buy some lottery tickets.
Okay, then let me say it to you this way. My advice to you, as someone who's been in criminal law for a very long time and dealt with many difficult situations and many upsetting situations, my advice to you is to decide that the personal aspect of this is done. Deal with this criminal charge in a way that puts a cap on it, and walk away.
That's what I'm trying to do. I didn't arrest myself for defamation of character. He came after me. Those signs been up for 2.5 years. I haven't done anything. The only thing I posted is Parents for Freedom, Father's Rights on Facebook. Look at how old those fucking posts are. This is retaliatory, really. 3 years later, give me a fucking break. They've just been
No,
up. They've just been up. That's it.
Right,
I
but
didn't come back after him.
But from their perspective, that's ongoing harassment. It doesn't end.
Well, what's a letter? What's a phone call to say, hey, Jason, I'm sorry for how I treated you in your fucking divorce. Maybe there's something we could work on. You know, this coming from an asshole bench representative judge. You know, something like that. A little letter from him. He has friends. I know his friends. I hang out with them. And I even told him, there's no hard feelings. I've had change of. But then the shit keeps coming back from my ex-wife. It doesn't stop from her. So if it doesn't stop from her, I have him to thank for the fucking problem. She wanted the divorce. I signed the divorce papers week 1. He knows that shit. He's the judge on the case. He knows that shit. I was done with it. I'm not the one that kept this going for 5 years. Lawyers love it. It's a divorce system. We all know how that works. I have done nothing but have been provoked, so every action I have is a reaction from her. It's just my verbiage is proper. And they don't like it.
Okay, well, here's our core pieces are that you have a right to trial. You have a right to jury trial. And that's what you've demanded. And be sure you show up for all your hearings and stuff because that's waivable.
Mm-hmm.
You know, if you don't show up, the court's going to waive it. And so, and I'll email you every notice that I get. And I hear you. That I don't want to make you feel like that I don't hear what your demand for is. I hear it. And I don't think it's the best choice, but my job is to give you information, advice, and you decide whether you take it or not. I'm not the boss of that. You're the one that makes the decision. I'm concerned. I don't think your decisions are the best. I think they're motivated by a lot of emotion and feeling. And I think that you're jumping the wrong way on some of these issues. But I'll keep pointing it out because I want to get through to you.
No, and
at the end of the day, you're the decision maker.
Right, and I understand what you're pointing out and stuff like that, but I've been going 6 years, and my boys are tired of it. I'm 40 years old. I have a past relationship. I know how to handle my shit. They don't. They get to come up and grow up 85% more likely to be up in jail. How is that not a predator? Because that funds the county. When you fill up more asses in those seats, and if you have 85% incarceration rate from fatherless children, well, that's predatory right there for the future position you're sitting on. There's plenty of ways I can say he's a predator. It's not my problem that Joe Public wants to think it's sexual. I'll prove it in how he's not. How he is a predator on every way but that.
Well, but some of those things, when you say that, that'll prove it. Statistics like that and asserting that there's a causal link that's the judge, and specifically Judge Parker, is not reasonable. I mean,
but his actions are.
Criminal justice system.
But his actions, they prove that that's the type of position he's enforcing and agrees with, and shows that before he was even on that seat, that's the kind of action he practiced, I guess, prior to having any kind of authority. So it just shows that he'll carry that over into his performance. And it does show it. I mean, case after case, I'm sure, but I only have to use my case. Shows it straight up, factually. He's done it to himself. I mean, I don't know why everybody's pissed off at me on this case. This is all because of her and them. Honestly, the only thing I've done is stuck up for my boys and use verbiage that is perfectly fitting for him. Cascade County Attorney Discipline violated student practice rules. HelenaAir.com. I'll send you the link to that.
No, I'm aware of that.
Oh, okay.
I was aware of that at the time it occurred. I know that happened.
Well, there you go.
They screwed up how they were doing that.
Yeah.
I know exactly what you're referring to. And so
makes sense to me. Continuation of that in a power position. There's no reason for him. He's not fit to sit. I lost rank in the military. That ruined my chances to ever hold those high tier positions. Same thing in the lawyer industry. You screw up something like that when you're young and dumb, too bad. Takes you out of the run-ins for a judge or judgeship.
Right, but that particular instance has no such effect. It was a mistake and a wrong thing and something they got spanked a bit for.
Yep.
That's all it is. It's not of such a degree that it has the effect you're saying.
It does, because it just shows that it continues into his practice now. And I have evidence of it. Look at my case.
Okay, nothing in that case file directly says things like that. As you look at it, it's contested litigation, and you were representing yourself, which was a mistake. When you say you presented motions and this was ignored and that was, you didn't do well, Jason. Any judge would have denied most of that.
No, absolutely disagree with you on that one. There was no reason for him to deny, ignore anything. They were feasible requests. Same request by her. Why can't I request the same requests?
The facts and circumstances didn't support it. Some of those requests, they weren't reasonable, and that's not the way it works. That if this one can do that one, then I can do exactly the same thing. Not necessarily.
Well, it just supports my cause for fraud, waste, and abuse. I mean, it shows favoritism, all that. There was no reason for him to ignore any of my requests. They started out proper. Nothing was abstract or too outlandish. Any of my motions. Not. I don't feel a single one of my motions was outlandish. And all justifiable. Absolutely justifiable for the situation going on. My children have no voice.
Okay. Well, but one thing that you're not going to get to do at trial is testify about those sort of procedural issues and then the search of the jury, because they have no ability to resolve or evaluate or do that. You can't present a motion to a juror and go, see, this was reasonable, and he denied it. They're not attorneys and judges. They can't even make that determination, nor will a judge ever allow them to. That's not, if you believe the judge made an error of law, your remedy is appeal, not try and
I didn't bring it to this. I didn't bring it to this. The divorce was done. I understand what you're saying. You can say this, I mean, repeat it. But I didn't put myself in this case. I didn't just give myself 2 charges of defamation of character. I understand the appeal of his bullshit, but that was done. The only reason it's getting rehashed is because I have 2 charges. That's it. I'm not the one bringing charges against him or anything.
And you don't want to have a discussion with the prosecutor of what they're willing to do if you will just let this stuff go. You don't want to do
I'm not the one that charged myself with 2 counts of defamation of character. This is on them. Everything is on them. This is a retaliation. 3 years.
And I'm asking, so if you don't wish to go engage in plea negotiations, I can't do it on your behalf.
I don't
can offer at some point.
I don't feel they're going to have any plea offered that is going to be any kind of gracious opportunity for me from them.
It's not. A plea offer in a circumstance like this is about limiting your damage.
Yeah.
It's not going to be gracious. It's going to be, it's going to be contingent on there being no more of anything like this. And they're going to want any contact, any statements to just cease.
Yeah. And that won't happen. Because that's silencing the abuse.
Okay.
That's it. I know they don't want to take a loss. I know they have a reputation they want to uphold. They see this as a win, we win, you lose type thing no matter what. I get it. I know the system.
All right. Well, I think that, first of all, the fact that you're here today tells me you can pay attention to details. You've asserted your rights. I don't want you to lose them. So I'll be sure that I get you notice of any hearing dates. Don't miss them, because the judge will waive that right.
Yeah.
And make you go to non-jury trial. And I am listening to what you say, and I hear that you don't want that. And so I just don't want there to be a mistake where you waive a right accidentally when it's important to you. I acknowledge it's important to you, Jason. I don't want you to feel like I don't. I'm just concerned because your thoughts and your feelings are extreme, and they don't fit with what most people are going to think. And I think that you've got a problem at trial because of that.
Well, then I guess that's just a chance I'm going to have to take, because my faculties are 100. I have a church that supports me. I have the entire congregation that supports me. So it is what it is.
Okay. Okay. All right. Well, we'll talk again, and we'll work on it. We'll get ready for trial as best we can. And I appreciate you taking the time, and I do appreciate actual discussion.
Yes.
And I want to do a good job for you, but I'm concerned at how some of this might turn out.
I understand.
Okay. Okay. Well, thanks a lot for making the effort today, Jason. And we'll have more talks. I want and if you got things you want to talk about, let me know.
Okay.
Set up a time. I don't want to make you feel like your time is limited in our discussions.
Right. But I don't want to waste each other's time either, So.
No, I don't either. But I want to be sure, in respect to you,
Yeah.
that you have access to me, and that if there are things we need to talk about, that we can.
Okay.
So I want to extend that and let you know that I understand that this is important to you.
Yeah.
This is not a nothing.
Right.
And so I do want to acknowledge that this is important.
Okay.
So I don't want to give you the feeling, because I have hundreds of cases, truly hundreds. So I don't want to give you the feeling that just because I have hundreds of matters that I don't recognize that this is significantly important to you.
Right.
Right?
Yeah.
So I want to express that affirmatively, because oftentimes I do talk harsh, but my job is to get through any way I can. So that my harshness isn't a lack of respect. It's that I do know this is important. So I'm trying really hard to communicate with you because it's important to you.
Right.
And so I do want to say that in that fashion, so that you don't find me unapproachable. I don't want to make you think that it doesn't matter.
Thank you for that.
So yeah. So I appreciate the time today, and we'll keep working on it. If I send a plea offer, it's not because I didn't hear that you don't want that. It's because I have a duty to extend any offer and give you my opinion on those things. Okay.
Copy that. Thank you.
Okay. All right. Well, hang in there, and I do understand the parenting issues. I've had my own divorce and all that kind of stuff. So I'm not belittling what that does to us and how significant of an impact that is on our lives, the lives of our children. So I do want to let you know, I don't come from one of those circumstances of someone who's never had anything go bad, and just don't seem to be able to understand that. So I do understand. I'm not saying that I had as much difficulty as you, but I had an awful ex, and I had a divorce and custody trial. So it wasn't agreed. It wasn't happy. It was awful.
Right.
So I'm not trying to be disrespectful of that circumstance and how important your children are to you. When I talk about letting something go, I'm not talking about.
Oh no. I lost you. Shucks. Oh.
to dial into another one, the Cut Bank City Court. I'm waiting my turn there too.
Oh, okay.
But that's just it. Is I just want to be sure that we've got good open lines of communication, and that doesn't mean that we agree. We don't have to agree. You don't have to agree with things I say. I don't have to agree with things you say. But we got to be able to trade those ideas and test them. You know, and then ultimately you're the decision maker. You know.
Right. Okay. That works. Like you said, it was a good conversation today. So, okay.
Mm-hmm.
Yep.
Yeah, it is. And we both have strong personalities, and that's okay too.
Yes.
You know, we can have strong words, and you know, we're talking about important things, and so all of that's okay. You know, but I do want you to recognize, and I think you do with some of the autism issues. Not everybody communicates the same way, and not everybody has tolerance for strong personalities.
Right.
You know, I found that in my life that I have to understand how. You know, I sometimes joke about it, like with my wife. I'll say, well, you know, I know how you humans are. You know, and so I want you to understand that not everybody's going to perceive those things the way you do, and a jury is not going to be made up of people like you.
Sure.
Just like they're not generally made up of people like me.
Right.
And so I try, part of my job is understanding how do other people think and hear things.
Okay.
You know, and so as you consider these matters, just factor that into your thinking.
Mm-hmm.
I'm not saying that means you have to decide things the way someone else would, but I think it's helpful when we make our risk assessment of how might someone else decide it. And I understand that sometimes we go to trial whether there's a risk or not.
Right. Right.
You know.
Okay.
Yeah. Okay.
Yes. Yes. Thank you for that. Good insight.
All right.
Thank you. Thank you.
All right. All right. Thanks. Have a good day, and thanks again.
You too. Thank you, Samuel. Talk to you soon.
See ya.
Okay. Bye-bye.